Welcome to StarTalks, powered by Advotalks. Today we have with us a very exciting guest, Madam Yanina Vlasenko. She is an international arbitration lawyer and she has been practicing in Russian as well as in the French law. So welcome on board and welcome to Advotalks, Yanina.
Hello, thank you so much for connecting. Thank you so much for inviting me here and nice meeting you today.
Okay. So we have a very interesting topic which will be helping for all the law students, the practicing lawyers, as well as individuals who are looking to explore their ambition in international arbitration. So the topic for our discussion will be how to become an international arbitration lawyer. So, Jan and I would like to ask you what has been your journey, how you became a lawyer and eventually came into international arbitration law.
Well, for me, it wasn't obvious at all because I was first planning to go into foreign language studies, and I was even planning and was actually taking courses with some private professors to become a translator or interpreter at one of the translation schools in Krasnoyarsk. However, it was both that my professors, they didn't recommend this education because translator nowadays is not a profession by itself, but rather something to apply to another profession. I was thinking about law because I was also good in history and because my parents were both teachers of history. Okay. And I was also good at social sciences. Some people told me that I was good at actually human rights and at argumentations, and that made me think about another career, a legal career. It was viewed as rather a challenging thing to enter the law faculty at a prestigious university. However, I tried. It wasn't that difficult as people told about this. And suddenly I was admitted and I started my journey first as a law student and then as a lawyer.
Okay. That's very interesting to know your trajectory of being into law and then eventually pursuing your career into international arbitration. So my next set of question will be, how did you choose the trajectory from a lawyer and getting into the international arbitration law?
Again, it wasn't obvious at all.
Okay.
Because at first, I was studying international law and comparative law, and we didn't center our studies on the aspects of international arbitration. Okay. I was of course confronted to studies of international law and especially multiple issues of public international law, which was first my first specialization at the law school. But arbitration, it really came later, and it really came when I moved to Paris. And this wasn't until I moved to Paris when I first decided to take a position of a first freelance lawyer at a Russian law firm that was resolving some kind of international arbitration issues. And then I came to one internship, then to another internship, and that's how my career in arbitration developed.
Okay, that's very interesting to know, as well as my next set of question will be that how can an individual choose this international arbitration law as a career? So what are your three recommendations or three steps which are an essential to become an international arbitration lawyer?
Well, one should really understand that it is not an easy journey. And there is a high competition. This meaning that one should really try to be very persistent. It means that unfortunately, you should be ready that you may at some point change to some other jobs or projects in order just to stay alive, in order just to be able to continue thereafter, because I haven't seen a lot of modern generation of the international arbitration lawyers that could start at arbitration and only lead towards arbitration and not do anything in the meantime. It's a very rare thing that one may do arbitration and only arbitration for a long time. Like you may be able to adapt, to switch to some other careers, maybe even not in legal field, maybe in some other fields, just to stay abreast, just to stay alive, just to be able to pursue thereafter. Like, especially if we are talking about cities with high competition, with a high value of life, like Paris, London, New York, well, you may not be able at some point of your career to have a contract at this prestigious law firm in arbitration, what to do thereafter. So you may have a plan B. So second, you should be rigorous as possible. I mean, it is very important for an international arbitration lawyer to be able to identify the necessary issues, to be able to really identify them correctly, put them correctly, so that your partner understands what you would like to tell, like the lawyer's colleagues understand, and also your client, which is also very, very important, understands what you would like to say, and that you say it in the terms persuasive, or finally for the tribunals or a client. And number three, I think also important, to be open to new cultures, new languages, and new legal methods, because arbitration, it's not only about application of the national law. It's very important to be able to grasp the concepts of the national law applicable to a particular legal system, but you cannot limit yourself to only this legal system if you want to really succeed in international arbitration. Thank you.
My next set of question to Yanina is that what is the difference between international arbitration and you can say a domestic arbitration, how they are differ, and what are the challenges way forward?
Number one is, of course, they are regulated by a different set of rules. For instance, if we're talking about France, there is a special set of rules in the procedural code which are applied to international arbitrations, and there is a separate set of rules which are applied to domestic arbitrations. So it is very important to distinguish which rules to apply to which particular situation, so that the procedure goes correctly. And the lawyer, of course, should be able to distinguish between this set of rules and between the national law of the place where the arbitration is seated. I would say that there are many similarities as well, because if we're talking about international and domestic arbitration, of course, there are some principles which are the same. So we are not resolving a dispute by a court, we are resolving it by some, I would say, non-governmental officials, which are non-employed by the normal courts, and which really, and who really try to rule on these issues differently. And I would simply say that in domestic arbitration, of course, like the influence of the local legal system and of the domestic law is always more influential. So, of course, if we're talking about domestic arbitrations, it is more guided by the rules of the national law, and as regards international arbitrations, it's more open towards different international rules, and of course the applicable rules will be also the rules of the particular institution or an ad hoc institution. And if we're talking about domestic arbitration, of course, most often it's like just the local law. And as regards some challenges and developments and traits for both, I would say that maybe the trends are really the same, because as long as international arbitration and arbitration in general is developing, of course, we are moving towards some trends as trying to ensure more confidentiality in international arbitrations. We are trying to move towards preserving the interests of the clients. We are moving towards trying to decrease the high fees of arbitrations. And of course, we are trying to move to some kind of more expeditious arbitrations, because the problem of arbitration proceedings is most often the time. So that's it.
Okay, okay. So now taking this conversation forward, what has been your observation of getting an international arbitration? How much it has been successful in solving the cross-border issues which are coming up?
So your question is whether it is useful to be able to solve cross-border disputes.
Yes, yes. How has been also addition to this, how has been your experience in handling those cases?
I would say that international arbitration and cross-border disputes and ability to really locate these disputes is very important. It is very important, and they are really intermingled, these two fields, and they are really interrelated. And without an understanding of where to locate this dispute, of what is the right court, what is the right tribunal for the dispute to go, it is really impossible currently to be a good arbitration lawyer. Why? Because one of the first arguments to come before the International Arbitration Tribunal is of course an argument saying that this tribunal normally does not have jurisdiction.
Okay.
So
yes,
an opposing party, which is normally a respondent, would try to get away from this dispute and to move it to another jurisdiction. And for this purpose, it is very important that an international arbitration lawyer identifies the problem from the very beginning and says, so what are the other potential courts where these disputes may be brought, and the opposing party, what will be their tactics? So what will be the court before which the opposing party may likely try to move this dispute? And what should I, as an international arbitration lawyer representing my party, could actually do to avoid this risk or to diminish this risk?
In order to understanding this international arbitration law, I will not ask you to reveal the names, but what has been your, you can say, satisfactory cases which you have dealt in? What were the dispute? If you can, we can have a discussion on any of the case which you have dealt in, and you felt that there was some set of amicable solution, or there was a sense of settlement which was a satisfactory journey for you?
I could tell you, of course, without any confidential details.
Yes.
Yes, I've had some kind of a dispute that went rather satisfactorily, despite the fact that we were first really thinking whether it should be an international arbitration dispute or a local dispute. Finally, it was rather local dispute. So despite the fact that we wanted to bring a dispute before the International Arbitration Tribunal, finally the dispute was brought before the local courts. However, we found the good arguments for negotiations, and in fact, before bringing the dispute to the court, we made a party really, in anticipation of the dispute, pay an important part of the debt. And he did pay the part of the money in debt. And then came also the local litigation procedure, and everything went fine. So he finally got all the necessary money. He got the money to be able to first initiate this proceeding, and later to be able to satisfy his claims.
Oh, wow. Yeah. As you rightly said, that there are certain set of, you can say, cases or disputes, which you can say put up a psychological imprint of every lawyer that gives a sense of joy or a sense of satisfaction, right? So, as concluding our conversation in this regard, after getting into arbitration law or becoming an international arbitration lawyer, what are the steps eventually a lawyer should follow to get clients, to get a network, or to promote his profile to become an international arbitration lawyer?
If we are really talking about international arbitration, if we are talking about a junior lawyer, and I might suppose that that is rather your question, correct?
Yeah, definitely.
So I would say it might be very improbable to get a good case for a junior lawyer and to resolve this case by himself. So either he finds some more experienced partner to deal with, to be in a partnership with, who would guide him, who would at least tell him how to get clients, and who would really also help him to get these clients. It is almost impossible for a junior to find immediately a client, like an important client or even a middle client in international arbitration, because it's a high stake. It's really a high stake with a lot of money. It's not like a family law where people would come to your small local firm and will bring you a small dispute. No, international arbitration, it's like normally, and as a general rule, you work for multiple years until your very first client that you bring by yourself. So really the rule is that first you really try to build your network, you really try to build your career success, your personal career success, and to be able to be really well incorporated into the international arbitration market. And I would say that it is always a job to do. It never stops. It never stops. When you have like several careers, several firms in international arbitration, you should always look for the next one. I mean, unless you really have a CDE, which is a rather exceptional circumstance here. And I would say that it is always necessary to really also focus on your particular assignments in arbitration, to do it at least satisfactorily, or better, good, or perfect.
Okay, that's very gracious of you of telling these practical aspects of international arbitration law and also about the profession. So I'll be concluding our session by a last technical questions to you, Yanina, that what are the
Yeah.
major arbitral institutions and rules commonly used in international arbitration law? If we can explore us light on it, so it will be an advantage for all of us.
Well, there are several, of course. It depends on the dispute.
Okay.
It depends on the willing of the party. It depends on what have they consented to in their treaty.
Okay.
In their, not in a treaty, maybe they have a contract, because most commonly the parties decide between themselves to what institution they bring the dispute. I do not currently have any statistics to show you and to support my conclusions. I would simply say that, of course, there are several most commonly adhered to institutions such as ICC and the local departments of ICC, such as the one most famous, which is in Paris. But if you are talking about ICC, it normally doesn't suppose that you're talking about a Parisian institution, because there is ICC in Amsterdam, there is ICC in other places. There is LCIA, which is a London Court of Arbitration. It's also rather popular. There is also a permanent Court of Arbitration, PCA, which also deals with international commercial and arbitration disputes. It is rather popular, but depends on whether parties choose this option or no. And there is, of course, ICSID, which is rather popular as well. However, it really requires a lot of money to be paid, just that so that this dispute goes through.
Yanina, it was an enriching session. So a closing note for all the audience from your end, as well as a special note for Advotalks, if you would like to give, and we will conclude this session after that.
Thank you. Thank you so much.
Thank you, audience, for your time, and we will be bringing much more technical aspect of international arbitration law inviting Yanina for all her insights in the coming future also. So stay tuned. Thank you.